lawyer, the private legal practitioner, or also a constitutional lawyer. Council Pokumi, Ewa Homasoda, Adopemini, no Edin Como. Council, good morning. What do you mean? Can we be able to dear? It's for Edgel. So, it's finally the Supreme Court, through the Judicial Service, at the report, at the about the final judgment in terms of the written word, Abba, acquire court, FR, so I want to again. Ninina is summarized in about 34-page document. Our more at the Ababeto Abonte. Mami Entio, I don't know, sir, what take your time to go through the report?
Yes, I have.
Okay. Oh, you're satisfied with concerns by a woman and the reasoning behind this?
One thing is, when it comes to legal issues, war an entity interpreting even the constitution or certain words are a war rather meaning in the minds of persons who have a case before the court. When the Supreme Court pronounces on that particular issue, a constitutional to the extent that that particular issue has not been set aside by the same Supreme Court, that would then be the prevailing law or the prevailing interpretation of a particular law. Also, be to say issue of birth certificate here. A lot of us don't agree with the kind of reasoning that went into declaring it not as a form of identity or identification document. But to the extent that the Supreme Court had made that pronouncement, if it's not set aside, it will forever remain in our books to say you cannot use a birth certificate.
Yeah.
And that's the reason for which the CJ nominee was also careful and said that in the best case scenario, it will be part of the source document it made me use. Even though you say somebody's a Ghanaian, but the parent is not a Ghanaian. Whatever can I say? Then the question is, did the person become a Ghanaian through nationalization or what? So if you are saying that you do not respect the birth certificate, but you rather will respect the Ghana card, and then we used to establish that Nipani Ghanaian, a woman a Ghana card, is that not the birth certificate? But of course, some of these, I don't want to use the word absurdity, but some of these hazy interpretation of the laws, we may not always get it right. They are human just as we are. Their understanding of the law may be different from the way we will also understand it. But your system, say, to the extent that that decision comes up by a body constituted as the Supreme Court, of course, we all have to abide by it. So there are a lot of things that I don't agree as far as this particular ruling is concerned. But I will still have to respect the view of the Lord because they are interpreting it from that standpoint. For instance, when it comes to the issue of citizenship, any allegiance issue here, I remember the last time we had discussions. The allegiance is not coterminous with citizenship. Incidentally, that is what they are trying to do. If I go before them and I'm going to make any arguments, because they have now, tied citizenship to allegiance, I have to argue along that line. And now say I will have to now go before the Supreme Court, edge on the Supreme Court with very, very sound and cogent arguments as to why they will have to depart from the present decision now. Almost can say citizenship is the same as allegiance. Now, I was just going through the ruling,
Yeah.
And then there is this issue about the fact to say, yes, before you are given a Canadian citizenship, you have to swear an oath of citizenship. Now, that oath of citizenship, in it, you also indicate that you bear allegiance to the Queen, right? And the Queen happens to be the Queen of England.
England, yeah.
Right. Now, is the Queen coterminous with the country?
No, we cannot say so.
No, because what is in our constitution, and it says the person should not owe allegiance to another country. This whole business of owing allegiance to the Queen, and the feudal system, and all those type of things. So that oath of allegiance, which is in that particular oath of citizenship, in respect of owing allegiance to the Queen of Canada, but not to Canada as a sovereign nation. I hope you understand what I'm saying.
I do, Council.
With the greatest of respect, I will say that it is a bit of a challenge for me to accept the ruling of the law to say Gyakye Quayson owes allegiance for the simple reason that he had a friend saying a Canadian citizenship at the time. No.
Now you go to the specifics. I think, sir, page 7, page 8 of the judgment. The written one is what I'm talking about. The Supreme Court makes the clearer definition for a year who is a citizen and then how citizenship can be in relation with allegiance. Now, let me read that portion. Now, ending combody year. Now, on the question of citizenship and allegiance, the plaintiff submitted that at the time of filing his nominations, the attention of the second defendant, in this case the Electoral Commission, had not been drawn to the dual nationality of the first defendant. The response of first defendant was that he had commenced processes of renouncing his Canadian citizenship and therefore did not owe allegiance to Canada. This position had found favor with the second defendant, Electoral Commission, which has led to their allowing the first defendant to contest the election, leading to the declaration that he had won the parliamentary seat of Asin North constituency. However, according to the plaintiff, the concept of citizenship and allegiance under the Constitution of 1992 had been found to be intertwined in the case of Asari versus the Attorney General, after reviewing the two concepts in the light of this particular report of the Committee of Experts on the proposals for draft Constitution of Ghana, represented by the PNDC law on July 31, 1991. This court, speaking through Atuguba JSC in the case of Asari versus Attorney General, had determined that citizenship, this is where is most important. So Justice Atuguba had, in the case of Asari versus the Attorney General, determined that citizenship and allegiance and loyalty to a state are interwoven concepts. One cannot be a citizen of a country and claim not to owe allegiance to that country. And Ahano is more emphatic, and per case law, it is stating, sir, the precedent as Supreme Court now established here to honor clearly indicates, sir, in our laws and per the interpretation as Supreme Court now kasa ediama, in some cases are etwemu a womu dikono obi ntimi nkase or a citizen na at the same time no one kase even though or a citizen but only allegiance to that particular country or bear womu citizenship no. This is a clear case example per precedent edaho. How do you respond to this?
there a woman is there. Let us understand the issue. Say you can't say BB and that twine that. It doesn't mean it is the same thing. What the laws have said this time, and they say citizenship is the same as allegiance. But what Atuguba was trying to put out, they say, when you are considering the issue of citizenship, you cannot, as it were, divorce it. You cannot divorce it from the issue of allegiance. That is what he was trying to say. And then he proceeded to say, you cannot say that you are a citizen of a particular country and will not owe allegiance to that particular country.
Exactly.
That is presumptive. Or not someone can say, what do you mean can say we are gonna need who owe allegiance? Right? So that in itself is a challenge. So the person no or caucus or no, as I said, ultimately establishing as a matter of fact, to say, yes, I'm a Canadian citizen, all right, but I don't owe allegiance to Canada. You understand what I'm saying?
How possible is that?
Yes, so that is where that issue will be brought before court. So when that whole issue says, we are Canadian citizens who owe allegiance, that issue saying owe allegiance, you have to prove it by fact and law. But I've told you just a short while ago, unless my reasoning is suspect there. But I'm saying that the Queen of Canada is not the country. Our how do you call it? Our constitution is clear. The person should not owe allegiance to another country. But when you look at the Canadian law, which even the second defendant, the third defendant, Attorney General, if we make reference to, it is the allegiance is towards the Queen of Canada, but not to Canada, unless we are being told to say when we make reference to the Queen of Canada, we are ipso facto saying it is Canada that is an issue here. But the Constitution was clear that you don't have to owe allegiance to another country. So for me, the allegiance issue, or whatever it is, as per the Canadian law, it is clear that you owe allegiance to the Queen. Now that we have Charles, your allegiance will be to the King. You understand what I'm saying?
Yes, I do.
At the time now, you can't wear a queen. It was because Elizabeth was there. Now that Elizabeth is not there, it's no longer going to be allegiance to the Queen. It's going to be allegiance to the King. So it is to the person, but not to the country as a juristic entity. No. So for me, the interpretation says allegiance is the same as citizenship. No. Yes, allegiance may be intertwined with, citizenship will have that very strong association or strong intertwining, with allegiance. But allegiance will not be the same as citizenship. Because allegiance is a commitment, devotion. Now, is devotion citizenship? Commitment, is it citizenship? No.
I see. Very interesting. I know there's a debate with those assertions what they pay. But the other impression I get upon reading the report, has to do with the issue of jurisdiction of the Supreme Court in presiding over such matters and making pronouncement. Now, the Constitution is very clear when it comes to matters a border on parliamentary elections, and then declaring a parliamentary election null and void. It has to be a jurisdiction of the High Court. Now, sir, the Court of Appeal to indicate after say parties, enti womo eho ase. Now the question the other council no raising, and the reasoning behind this no which is not quite clear to me no is the fact is the case of Gyakye Quayson how do you call it, High Court. From the High Court, there were certain things our parties NTS here. Then they move on to the Supreme Court for interpretation of certain clauses and articles within the 1992 Constitution. My point is that it ought to have come back to the High Court at the time. Parties, especially the council for a year Gyakye Quayson, are filing an appeal on the High Court decision entirely. One more ateki. Now the question I ask again is that how does the Supreme Court have jurisdiction in making such pronouncement and making such reasoning at the time one more so abba with a writ instead of a petition in addressing such a matter?
Well, so maybe a can't say you say higher crime. I will plead with you not to lead me into temptation.
Oh, counsel, when in your temptation, but this is law.
No,
these are the provisions of the law.
No, never. The test will be so. I'm not a timorous soul at all. But I am just trying to measure what I will say so that I don't sound offensive.
Okay.
I hope that is why make us say higher crime. If I were to be talking to one-on-one, I may say things differently. But the Supreme Court, as per the Constitution, have the mandate to review or to depart from its own decision.
Exactly.
So if the Supreme Court has said something some time ago, again, the parties before it will have to convince the Supreme Court why it should not depart from its earlier judgment or ruling, but must stick to that particular one. Where you do not do that, obviously you will give the Supreme Court the leverage to even depart from its earlier decisions, because the Constitution even supports them in that regard. Where I felt very uncomfortable was when the Supreme Court made the order that Gyakye Quayson should not be allowed to go to Parliament. That is when the injunction was filed to restrain him from going to Parliament. At the time, we were then dealing with electoral issues, which young Constitution is clear about to say it must be dealt with at the
High Court.
The High Court, or on appeal, at the Court of Appeal, and that is where it will end. So electoral matters never find their way to the Supreme Court. But if you look at this ruling which came in, it is a complete determination of an electoral matter.
Exactly.
I mean, the constitutionality or whatever it is, that one is just a ruse. The whole thing is the election matter, which has been garbed in another way and brought before the Supreme Court. So I feel very uncomfortable with what is happening, because we are not going to have situations where people, when they realize they are not getting things their way, they will just garb their petition, election petition, as a constitutional matter, bring it before this thing. Because I would have expected the same. What the Supreme Court ought to have done would have been to make the determination in respect of the, in respect of the allegiance interpretation.
Yeah, and the nationality,
Yes, and then remit the matter to the High Court, for the High Court to make a determination on that. You understand what I'm saying?
Exactly my point too.
Yes, but if the person just came in there wanting the interpretation of it and then seeking consequential
declaration
orders, and declarations, say, as a result of that, Parliament, that is an electoral matter. It is not a constitutional matter. So if they were going to court, the Supreme Court, the sole issue that they ought to have sent to the to the Supreme Court was Article 94(2)(a), and for the court to make a determination on that. And when the court has made that clear determination, then it will remit the matter to to the High Court. Because take note, at the High Court, this issue has been raised, and the judge has rubbished it and said that Article 94(2)(a), is clear on allegiance and blah 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 blah.
Kessben 92.9.
You understand what I'm saying? So
yes, I do, Cousin.
If we are not interpreting the issue of allegiance, we interpret that alone and remit the matter to the High Court, and for the High Court to make the order. And if the parties are not satisfied, they go last stop being the Court of Appeal. What came out yesterday, if you read the whole thing, you will see election petition standing, jumping, dancing in it. It is never a constitutional matter, if you ask me.
I ask so because there is also a precedent. There is a case, a year authority in buttressing all this. In 2021, Republic vs. High Court, who ex-party, the Attorney General, and then Professor Margaret Kweku and others, interested parties, has to do with a year Orua Peter Amewu Hohoi constituency,
I remember that. But that's what I'm saying. But there's also a certain caveat of proviso.
Kessben 92.9.
Yeah.
Yes, they declined jurisdiction. Gave reasons for declining that jurisdiction. This time they didn't decline the jurisdiction. And they explained why they did not decline the jurisdiction. And again, as I have told you earlier on, the Constitution allows them to review their opinions.
I see.
That is what we should always take note of. No one to work at, because there is a certain clause, a saving clause, and that is what they can use, to make their case.
Now, upon reading the final report, unya impression say Gyakye Quayson ain't mean contesting in the upcoming election, and
No. Gyakye Quayson will contest. Don't contest. There's nothing that debars him. There's nothing that debars him from contesting. What was the issue was that he was having Canadian citizenship, right? Now that issue of the renunciation certificate has even come. So to the extent that he has a renunciation certificate, which evidences the fact that he's no longer a Canadian citizen, he can now stand.
Yes, but to face a criminal trial.
Yes, the criminal trial, there are two issues that will have to be proven. The mens rea and then the actus reus. That the act that has landed him in court, and then the intention behind the said act. The intention that Gyakye Quayson have in filing his nomination form or in going for the for the passport. They didn't have any criminal intention. As far back as 2019, he has returned his Canadian passport to the Canadian authorities, and there are documents to evidence to say those items, have been received by the Canadian authorities. He was in Ghana, so if he wants to travel outside of Ghana, how will he go?
Kessben 92.9.
He will not necessarily be going to Canada, but he will be going to Britain. He will be going to France. He may be going to Italy. How does he go? Or Ghana? Into Wakakoji, we know. And then as per his understanding at the time, or say maybe the passport, I return it to them. I have also started the process. It is bizarre me say we owe allegiance. My understanding as at then was that I didn't owe any allegiance, because things that I can pride myself with, and to say that I am a Canadian citizen, but the only name so I cannot be considered as a Canadian, and much less for it to be said, I owe any allegiance to the said, And yes, as I have said, even that aspect of owing of allegiance, I'm saying, my understanding is that I'm no longer a Canadian because I returned their passport to them, and I have also rating to them, announcing to them the cessation of Nigerian citizenship. The passport. I don't have any menstrual. I don't have any intention of deceiving the officer from whom I collected, and now as it's described, forgery under the passport law. No, that one constitutes forgery. Even if you don't do anything, if you give information which is found not to be correct, in quotes, that one is described as forgery. So for me, yes, he will go to the court. The issues will come up. The lawyers will speak, and I am expecting, we will let justice really prevail. Justice not just because it is going to do just for the purposes of distraction, but justice for the purpose of building.
Okay. Council, I'm grateful for your time.
All
right. And the constitutional lawyer Paul Kumbe and Benino Edin Commod, bringing us to exactly 16 after 8. Kessben 92.9, Kessben Television live on DSTV, channel 364, Go TV, channel 121. All the messages at the bar. Yabeke Kaini at the Abba. Medina Kwame appear could be very interesting. Already report by the Supreme Court the revelations in there. And the president, one more cited per case authorities, backing one more reasoning, quite interesting. And just as lawyer Kumi was saying, the Supreme Court has every right in reviewing its own decisions in that effect. And they may take a position today, tomorrow they may depart from that particular position and also allowed as part of the court processes. And that is it. Now, it is short. Explanations are not minority the justification here reason a Supreme Court because the Assent North seat vacant. The Electoral Commission and the Parliament must initiate processes to ensure a by-election I mean, if you get the report and you read that, then you can make a fair assessment for yourself. And my message is all the